Attorney-client privilege in North Carolina is, I think fair to say, is complicated. In some ways, it's complicated because of the unique nature and circumstances of who your client is, more so than the information that's being shared. So for example, there are certain privileges under the common law of North Carolina. That's why we call them common law privileges. And we are one of the original 13 colonies in North Carolina. So the laws that came over from Great Britain that were commonly known, we refer to them as common law, are part of, we still have vestiges of them and are still part of the criminal laws in North Carolina. So there are privileges. You may have heard the privilege against self-incrimination. You may have heard the priest petitioner or penitent privilege, where you tell something to your pastor in a confession. You may have heard of something called pillow talk, where conversations, the spousal privilege or spousal exemption, where information shared between spouses is deemed privileged. And then one of the most important privileges, at least from a perspective of a criminal defense lawyer, is the privilege of the information that's shared between a client and the attorney. We say that's inviolate, meaning that we hold it close to us. We don't share that information unless we have permission of the client. Now, as is the case with most privileges, there are always certain exceptions and considerations. For example, the marital privilege, there are times where it may apply, there are times it's not applied. The courts tend to very much protect the attorney-client privilege because we really want to encourage clients to tell their attorneys the truth, the whole truth. In my instance, I want nothing but the truth, so that we can provide sound legal advice. The question is, in relative to juvenile court cases, is if I have a parent sitting in there, whether or not that privilege is extended to the juvenile. My opinion, and there have been some recent changes to the juvenile justice laws in North Carolina, so we're kind of developing this within the last few months even, and now being 2020. My opinion is if they're under the age of 18, clearly they're still considered a juvenile under the laws, and as a parent, you have a right to have an attorney or parent present. I would seek to enforce that privilege, meaning that if a parent decided to testify against their child and they were part of the legal representation, I may have a problem with that. On the other hand, if the person's 18 years of age or older, or they've been emancipated, or there's a prior felony conviction in adult court, you may waive that privilege by having multiple people in the room other than your attorney or your legal staff at a criminal defense firm. Long and short, there are a lot of rules and exceptions to the rules. It's worth sitting down, working through these things, explaining the different options, and helping you understand what I believe is the best way to proceed in court, or the smart way to proceed with criminal charges in Charlotte. Give us a ring. The consultation's free. It's 704-342-4357. My name's Bill Powers, and I look forward to hearing from you.